May as well. You started recording. So thanks, Joel. Want to give a big shout out to Joel Lawrence for getting us back on track with these Indigent Defense Coordinator meetups. He'll be in the background today. And my name is Wesley Shackelford. I'm Deputy Director of the Indigent Defense Commission. And I think we've got a great program today for everybody on mental health and the indigent defense system. And so we're going to, first thing is we have two speakers, and Jay Wooten is the Chief Defender from Galveston County, and it's the Galveston County Mental Health Public Defender. So it's a very focused program representing defendants in misdemeanor cases, and he's going to be able to talk about what a well-staffed indigent defense defender can look like in terms of dealing with the defendants with mental health issues. And then he's going to turn it over to TIDC's own Bill Cox, our Director of Public Defense Improvement, and he's going to walk us through the JCMH's mental health checklist for counties. And so that's actually mainly what the slides are going to be about today. I don't know if we want to go ahead and start the PowerPoint, because the next thing we want to talk about was getting folks credit for this. We were able to get CLE credit for the program. And I understand that that is real important for, well, obviously for attorneys, but also for IDCs who want to get credit through the Texas Center for the Judiciary. So that's going to be our goal with these meetings, at least where there are, legal issues that we think can get CLE credit, we're going to apply. So, yep, on screen now, we've got the course number. Of course, if you miss it right now, it's on the PDF of the slides. You can go ahead and download from the chat where Joel has posted them. But we want to be sure y'all get your hour of credit for attending today. And I think with that, 12:03, we may as well jump in. So I'm going to turn it over to Jay Wooten. And at this point, I'm not sure we need the slide, but Jay, can you, I only see a couple of people across the top of my screen, so you want to just start talking and maybe you'll pop up for us.
Sounds good. I think I was muted at the beginning. I usually am in these talks. My name is Jay Wooten. I'm with the Mental Health Public Defender's Office in Galveston, the Misdemeanor Mental Health Public Defender's Office in Galveston. I didn't do any slides because, to be honest with you, I'm trying to throw in kind of what we're doing down there in 10 minutes. And I don't know that the slides would really help. They'd be pretty quick. So maybe just let all this kind of wash over you and maybe give you some ideas of what you might be able to do in your practice. I always start off by saying I really appreciate, first and foremost, our judge, Wayne Mallier, who hired me and is our mental health judge and does so many things for our docket. Jack Rohde, the DA, because this is we have a collaborative diversion docket that we work on. And without him, none of this would be possible. And I want to tell you that when I lay all this out, if your name is Rocky Glass or Melissa Shearer, you'll say, hey, that's all my stuff. And I'll say, yes, it is. I stole every bit of it. And then I galvanized it because the island, does what the island does. Anyway, so first off, I want to tell you that to tell you what we do, I mean, we have 4 attorneys, 4 caseworkers, and an admin. But to tell you what we do, I have to tell you where we work and what we work on. And that is a mental health docket, not a mental health court. Mental health court, of course, is a specialty court, and y'all are all familiar with that. And we have one of those, and Judge Mallier, and I'm sorry, I'm getting over a cold, so please bear with me. Judge Mallier runs that, but that's a whole different program. And of course, that's post-conviction, post-plea. Everything we're doing here is pre-trial. In fact, it's really starting from the inception. The problem, of course, is that people were going through, the people with mental illness in most counties, including Galveston, were going through, we passed the days where those people were languishing in jail. In fact, quite the opposite was going on. People were coming in, and when they were being identified, either either because of their effect or because they were known to law enforcement, they would get 3 days in court costs and just go right back out. It was just a revolving door. And they were given a piece of paper saying, hey, please go to the local mental health authority when you have a chance. And they'd say, sure. And of course, that would never happen. So, using the 2017 Sandra Bland Act and the evaluation under 1622, all that is just an evaluation that people do of everyone that comes into the jail and doesn't bond out. And it ultimately, if there are two things checked at the bottom, that somebody has a chronic disease or illness, or mental disease or illness that's chronic in nature, and that outpatient services are available, then that lets everybody know that that person has that. A lot of times that's based on a CCQ, which is the continuity of care quotient, which I term, the TCIC, NCIC of mental health. But anyway, they run people and they'll show up. Anyway, if those are checked, what we do is we immediately get that information from two ladies who work for the local mental health authority and are actually embedded in the jail. And they send that over to us, and we fill out a referral for our docket. Now, let me be real clear. We do not take these people out of their home court jurisdiction-wise. They are still in those home courts. You do not want any part of trying to transfer a court into another court. Plus, we don't have a separate court. We just have a docket. This is really very similar to when they say, okay, Judge so-and-so has a jury, numbers 18 through 35 on the trial docket, go down to County Court 4, and they're going to try your case there. It's still in the county court you came from. So that's really important. So we do that. We do all this really quickly because we want to get these people off of jail docket. We don't want that 3 days in court cost in and out in 24 hours. So they get those affirmative findings will get us a referral. When our judge signs that referral, then there is a standing appointment order from my office to represent those people, every one of them. Now, if it turns out down the road they have an attorney, we step aside. No problem with that. The other thing that we do in Galveston that is great, because we have a mental health public defender's office where everybody is on salary, we just take everybody. We don't worry with the indigency. We don't worry about all that. If nothing else, it's just a time waster. What we want to do is get to seeing these people that day. And we almost always do. We almost always get a chance to go over. Now, I had a private practice. I know what it's like to try to see people that day. I'm not saying, obviously I'm cheating, because that's all we do. But that's what we do. We get over there and see them that day. And what we're trying to do, because even if they're getting treated in jail, it's nothing like getting connected to services at the LMHA. A lot of times it's not the right medicine, et cetera, or they don't have a prescription and that stuff. So still in the same court, standing order appoint us. I'm sorry, I'm trying to go through what I said here. I'm trying to stay within my time limit. Okay, so we get them, we try to get their case filed as soon as possible, because the Galveston County Clerk's Office doesn't understand how to bring somebody over if the case isn't filed. We're working on that. But we get their case filed and then we bring them over. And of course, under 17032, via the 1622 evaluation, we ask for a mental health bond and try to get them out. That, of course, if they don't have a Class A pending ACBI family violence, or they don't have any of what I call a 3G list, it's not really the 3G list, but it kind of looks like it, then they're eligible for a 17032. Also, we ask for a no-fee pretrial release bond if we still have that 1622. And if the DA's office agrees, like let's say they do have that prior assault charge, family violence, but the same victim, it's their mom. And, people with mental illness, they assault their care workers sometimes. And if it's a Class A or whatever, and they're on board with getting them out, then we still want to get them out. And a lot of times our judge will grant those. Then we have our judge, and this is the real key, and I stole this straight up from Austin. We do a warm handoff. We make sure one of our caseworkers is over there to get these people when they're released from jail at a certain time. Our jail is great. They do that for us. They release these people, and that way we can take them straight to the local mental health authority. A lot of our clients are nomadic, they're homeless, or houseless, or unhoused, and we can't find them again. And we want to get them over and get them an evaluation, even if they only get an evaluation and a prescription, and we never see them again until the next time they're arrested. That prescription is now on file, and the jail will fill that prescription if they have that medicine the next time they're incarcerated. So that can really help us. There's a standing, by the way, I left this part out, I'm sorry. The judge will give them bond conditions, add to their bond conditions, whatever they are, that they have to go to mental health, seek mental health treatment. That's part of 17032. He also adds that in a no-fee pretrial release bond if he grants that, and also check in with our probation bond officers to make sure we keep track of these people. It's a collaborative diversion docket. There's a standing offer that if our people go to 2 consecutive appointments at the local mental health authority or wherever they seek mental health, that any non-violent case can be dismissed. Not assaults, those are case by case, no pun intended. We're getting most of those non-violent cases dismissed now, which is great. And of course, that's all due to the DA's office going through this program. I know a lot of people are thinking, well, that's great. You've got this collaborative docket. What does that mean for me? I think it means for you that maybe if you approach a prosecutor in a regular court in your practice, maybe you can tell them that these things are happening in other courts and that they might consider something like that. Now I'm going to jump real quickly over to the people that we have that are incompetent, because I'm almost at 10 minutes right now. We go with 1 evaluation. Everybody in the county agrees to go with that evaluation because we're trying to save money. If they're found incompetent or evaluated as incompetent, we don't find them incompetent because that causes trouble down the road. We then approach the DA's office and we reach out to the provider in the jail and we seek civil commitment first. We try to see if we have a psychiatrist on staff that will actually find whether this person is a danger to themselves or others, or also there's another less used prong in there about not being able to self-care. If we can get that, we get with the DA's office and we dismiss and transfer it to probate for civil commitment. And then that person gets medicine at the hospital. That's great. We've gotten our client to a hospital. It's a huge win. If they don't, then the DA's office knows that based on the way the state hospital is now, no one charged with a Class B misdemeanor or probably a Class A is ever going to make it to the state hospital. We have JBCR, jail-based competency restoration, but it's not a huge, and it's really taken up for felonies. So the DA's office will go ahead and dismiss that case, even though they haven't timed out. You may not know this, but the law says that if somebody can't be held longer awaiting competency restoration than the maximum they could get in jail. We first went to telling the DA's office that that should be 2 for 1, and they bought that. And then now we basically just try jail-based. I mean, we try civil commitment. And if it doesn't work, then we ask for it to be dismissed, and it is. And I think that's something you can definitely do in your own practice and in a court and tell people, look, there's no reason for this person just to sit here and take up space in the jail. And by the way, jail exacerbates a lot of these people's symptoms, as you might know. I'm wrapping up now. I will tell you that the caseworkers make my office work, and because they do the hard work of getting these people to their appointments, and getting them to their appointments and connected to service is what we really need. Jail doesn't help. Rehab doesn't really help. What they really need is medicine most times, and that's what we try to do. And I'm sorry that went so fast, but that's 12 minutes and 25 seconds.
No no worries, Jay. I think we're turning over to Bill now. Thanks, Bill.
Thank you, Jay. And that leads us into the discussion we wanted to have on the uh, Texas County Mental Health Checklist. You've got the entire checklist at the end of your PowerPoint, as well as on the link that we put in the chat. However, instead of going through it and just reading the checklist to you section by section, we wanted to go through and try and digest it a little bit and hopefully make it a little more usable for you. The first part of that is it's got a lot of acronyms. And so instead of just diving into alphabet soup, I want to give you a little bit of context first. We all hear about HIPAA. It's the Health Insurance Portability and Accountability Act. More importantly, it creates significant protections for personal health information, or PHI. One of the things we're going to talk about, though, is there are exceptions to HIPAA which have been passed. One of them Jay was talking about with continuity of care, which means even though information would normally be privileged, normally be protected, there are certain circumstances, including for people who find themselves in the criminal justice system, that allow that information to be shared to facilitate their having treatment and to be sure that we have the warm handoffs he was talking about that are what are so necessary for people with severe mental health issues to get the treatment they need. A couple of other terms you're going to hear are local LMHA, the local mental health authority, and LMHP, a licensed mental health professional. You'll also hear about a BHA, which is the local behavioral health authority. You've probably heard a lot about mental health, which is what you would think of with just someone with severe mental illness getting treatment. We've all had some form of local mental health authority, and used to be mental retardation, intellectual developmental disability providers in our communities. But the local behavioral health or behavioral health providers are something that's evolving more, and yet it recognizes one of the big challenges we run into with mental health, which is people who don't just have a mental health diagnosis, but they also have substance abuse issues. So behavioral health will deal with both of those issues together. Another new term you'll hear is the LIDDA, LIDDA, which is the Local Intellectual Disability Developmental Disability Authority. This used to be part of your MHMR, but it deals with services for people with severe developmental disabilities. Typically, it's going to be an IQ under 70. You will also hear about an emergency detention order, or an EDO. You're going to hear about jail-based competency restoration, as Jay mentioned, or JBCR, or maybe jail restoration. You'll also hear about a QMHP. The QMHPs are a qualified mental health professional. And then again, when you hear about CCQ, that's going to be incredibly important as we start these discussions for the continuity of care, to be sure that that information flows forward, and the CCQs are that initial query, which is going to be a lot of what will help flag you when you're working with someone at the jail to see if there may be mental health issues. And some of this, stepping a little bit out of the mental health piece and into what you deal with as indigent defense coordinators, is it may be someone that you get an incomplete application from, maybe where there's information that doesn't make sense. And so checking that information lets you know this may be an individual that needs an appointment of counsel in the interests of justice because of their mental health issues. So with that very quick, high-level discussion on some of the terms that we may be talking about dealing with systems, let's start talking about sequential intercept mapping, or SIM mapping. And the sequential intercepts come to us from SAMHSA, the Federal Mental Health Authority, and they look at how to analyze what's going on in your jurisdictions, see what services you have that can help someone with mental health issues, with intellectual developmental disability, and what are the ways to divert them out of the criminal justice system. The first area it looks at is what are the systems as a whole, and education. Then it's going to look at 5 different intercepts, actually 6. The first one is called community services, 0 before anybody ever gets there. Then we have that initial law enforcement interaction. The next step is initial detention or initial court hearings. Then the actual court case moving forward, and then reentry. What happens when the charges that brought someone into the criminal justice system are resolved, and ultimately community corrections, which is if that person ends up on some type of supervision like probation after their case is resolved, how do we effectively deal with their mental health and intellectual developmental challenges at that point? So with that, the first one is, as we're building our community services, we've got to involve all the stakeholders. You're the stakeholders. The magistrates are the stakeholders. All of your judges are stakeholders. Law enforcement, your defense attorneys, your prosecutors. And if your prosecutors are different from whoever handles the civil commitments, as Jay was talking about in your jurisdiction, for instance, your prosecutor may be the district attorney. And if you don't have a criminal district attorney that does civil and criminal, then it may be your county attorney. All need to come together and talk about what's going on, what are your resources, and what does the law permit to happen to effectively deal with people with mental health issues. One of these is when we talk about the HIPAA information. There are specific exceptions in the Texas Health and Safety Code, and all of these sites are in the checklist at the end of the PowerPoint that authorize the sharing of mental health information, intellectual developmental disability information, even physical health information other than alcohol or substance abuse treatment to facilitate continuity of care, to be sure what's going on with that person is effectively addressed, they get treatment to deal with their issues. It's incredibly important to be sure all the stakeholders are aware of it. It facilitates the information flowing quickly. It helps to get the information going from the jail to you so that you know if there's something weird when you see that application for appointing counsel, to the prosecutor. So as Jay was talking about, they can look at, is this somebody that they want to go forward on? To the defense attorneys so they can advocate with it. And then not just from the jail when they do their initial screening, but also to the magistrates who are setting bond, who are looking at the appropriate conditions, and to the jail's clinics to be sure they have all the information they need for treatment. And then, of course, we talk about reentry, getting to your community providers, whether it's mental health, whether it's behavioral health, or whether it's the developmental disability. All of those need the information to flow, and they all need to be aware of it. Otherwise, one group reaches out and the answer is, that's protected, I need a court order, or you'll have to subpoena it, or I need a release. All of which causes more time for people in jail, causes more deterioration in their conditions, and potentially increased costs for your county, as well as those delays for the defendants because of the additional need for medication and the additional work to get them back into an area where their needs are effectively treated. Along with those stakeholder meetings is communication. Look at your local data. How many people do you have in your jails that have serious mental health issues? How long are they staying? What type of charges are they coming in with it? What are the things that are causing it? And then education is going to be a recurring theme as we keep going through this. One other item is look at your indigent defense plans that all of your judges submit every other year to TIDC. This coming fall will be a year to update them. And see, is there a special mental health list? Do you identify attorneys with skills dealing with people with mental health or intellectual disability challenges? Is there a separate fee schedule for people with those needs to both provide an incentive for the attorneys and to recognize the higher level of work and commitment that's needed to effectively work with someone with mental health or intellectual disability challenges? And then is everybody familiar with the health and safety code requirements? So let me move forward. This is going to be, as I said, a very quick overview, but to that first level of Intercept Zero. What's available in the community? Are there pre-crisis services that people can access? Is there regular conversations going on with your local mental health authority, with your intellectual disability, developmental disability authority, with your behavioral health authority to educate the community on what's available, what services they have, how someone with mental health needs, with substance abuse needs, with developmental disabilities can access their resources and get assistance proactively before there's an encounter with law enforcement? Is there some type of assisted outpatient treatment available that people can get? Are there crisis services in your community? What are the phone numbers to access the crisis lines? How's that information shared? Even before, again, we get to normal law enforcement intervention, if a family member seeing a crisis with someone with mental health issues, with substance abuse, with intellectual developmental disorder, uh, is there education about emergency detention? This is the process where a family member can go and swear an affidavit describing the behavior, describing why intervention is needed, why there is potentially a danger to themselves or someone else from, and it doesn't necessarily have to be a relative, it could just be someone they know that's reviewed by a magistrate, could be the probate judge. The probate judge may have delegated that authority. And then a temporary detention can take place where the person is taken to a mental health facility to get stabilized, get evaluated, and get treatment. Is law enforcement in your jurisdiction aware of warrantless emergency detentions? There's authority under the Health and Safety Code for those. Or do they all have to have a warrant with the emergency detention order process? And then we get to our next intercept with law enforcement itself. The Code of Criminal Procedure in Article 1623 requires law enforcement to make a good faith effort to divert when it's appropriate. If they see somebody is having a severe mental health crisis or suffering the effects of substance abuse, to a proper treatment center. And again, this comes from the quarterly meetings you're having with going over your local data. Is that happening? Do you have law enforcement coming into your local jail, someone who's clearly in a mental health crisis? Was there an attempt to try to divert out? And then what were the circumstances? Because the diversion's only required for nonviolent misdemeanors, and if there's a mental health or substance abuse issue suspected to be the reason for the offense. But this requires also not just having those stakeholder meetings, but getting everybody on board to gather the data. The jail intake staff, what do they see coming in the door? What are people presenting with? What is law enforcement met with when they go to try to divert with mental health facilities or substance abuse treatment facilities? Another option that we still have is warrantless emergency detention. Did law enforcement decide to go to get treatment rather than just moving forward like a standard case and seeking booking into the jail and magistration? And then Texas also has additional options under the Code of Criminal Procedure for law enforcement not to make an arrest. There are specific types of cases where an arrest is required, such as violations of court orders or bond conditions related to family violence, child abuse and neglect, child sexual assault or abuse, indecent assault, stalking, and trafficking. But for most offenses in Texas, detention is discretionary. And again, that's not to say that the case would not proceed forward, but the immediate step is to try to stabilize the person and deal with what's going on so that then the court system can be proactive rather than just reacting to an acute situation that's happening. The next intercept is once we've gotten past that initial interaction with law enforcement and the decision to take someone into custody, we look at the initial detention and we look at the court hearings. So first part of this is jail diversion. And Jay talked about the CCQ, looking at the information. Does this person have any prior history of getting mental health services anywhere in the state? The Texas law enforcement electronic information with the CCQ is incredibly helpful because it doesn't just look at one county or one region. It looks at whether this person has received mental health care from a state facility anywhere statewide, especially if you're in an area where people may tend to go back and forth across county lines frequently. This vastly increases the information your jail staff has with someone walking in the door. Now they're not looking at just the information they've got from their interactions with this person, but they're able to see what's happened statewide, what prior diagnoses are, and what flags may be, what past treatments have been made available. And then another piece to looking at this is, are there telehealth services for mental health, for behavioral health 24/7 that can be used by the jail staff? Are they aware of how to access them to facilitate addressing crisis, to meeting the needs? And then, of course, the other one is, do defendants who come into the jail get their proper mental health medications? One of the significant challenges for people with mental health going from the community to detention is the jail may use a different formulary. Is the jail aware of what the defendants are normally receiving? Are they able to get the same medications they were prescribed in the community? And then, of course, we're just walking in the door of the jail. The next step that has to happen is magistration under Article 1517. Are the magistrates getting timely notice of that information from the jail? And this is the 1622 hearings Joe was talking about. But one point I want to make with 1622, they absolutely have to happen when someone's coming in the door of the jail for that initial assessments. But 1622 is not a one period in time and it's over. Somebody may have a past history of mental health, and the magistrate decides there is not a reason for the 1622 assessment to go forward at that point. The person may deteriorate in jail further, and there may be another need for it in the future. And it's very important, if you see it, like when you get again a indigence application that looks like someone may not be understanding, may not be able to communicate information, to pass that information back to the jail staff, back to your magistrates, so they can again reassess if there may be a need for a 1622. And it may also be a reason that you need to appoint counsel in the interests of justice. Once they get the 1622, then they order the assessment. And when that information comes back, it's vitally important that it goes both to the magistrate that ordered it, if the case has now been filed, to the judge hearing the case, and to the prosecutor and to the defense attorney. All of them need to know what's going on with the information and with that client so that they can look into it, investigate it, and use it as they move forward working on this person's case. And then, of course, the other item we get after 1622, as Jay mentioned, is mental health bonds. If someone has mental health issues and they do not have a violent offense or a conviction for a prior violent offense, as Jay said, those of us who've been practicing a long time call them the 3 Gs, but basically it's anything that's an aggravated felony or anything other than a family violence that's going to be a felony causing some type of injury, then they are entitled to a mental health bond. And the mental health bond, again, focuses on the health and safety code's priority to treat people in the least restrictive area possible. And if someone can be treated in the community, then we get them out of the jail. People with mental health tend to decompensate in your jails. They are some of the most expensive people to house in the jails because of their needs, because of how they may be presenting with their mental health challenges. And if at all possible, there's more community services which are more cost effective in the community. So if we go to the third intercept, we get to the courts. And that one, there's several different areas. One is diversion out of the system entirely. Are there diversion programs in your jurisdiction to divert people with mental health issues, to have them get some type of assistance in the community and then ultimately get their charges dismissed? Some of those could be like Jay talked about with the civil commitments. Some of it could be programs where you have a nonprofit or other provider in the community that provides services and assistance to get the person stabilized and get them on their routines. A lot of your local mental health authorities will have what they call different treatment packets, which are essentially levels of care. And they can start at a much higher level depending on the person's needs, and then slowly step that down as the person is stabilized, begins accessing services, and gets a routine in place. Are there mental health courts? Mental health courts can work like what Jay's talking about with the dockets in Galveston. to divert someone completely out of the system. They can be a post-conviction treatment court, which provides significant supervision and oversight using a model that is developed based on dealing with people with developmental disabilities or with serious mental health issues. Again, focused on getting them med compliant, helping them understand their triggers, and helping them avoid future involvement with the criminal justice system. And then we get to another area that comes up with courts, which is people who may not be able to even move forward with their case. Simply put, the legal term is they're not competent. But do they understand what's happening, or are they able to both understand what happens in the court and talk to their lawyer and help their lawyer to defend their case or do whatever they want to have happen with their case? For people who aren't competent on misdemeanors, it can be an incredibly long wait to get a state hospital bed if one even becomes available. For felonies, likewise, the wait is very long, but there are several different options. One is there's jail-based competency restoration, which provides services similar to what a person would get at the state hospital to try to help the person become competent, to get their medications in place to deal with their mental health issues, to understand how the criminal justice system works, to understand the role of everybody in it, and then to help them to understand what their choices are in the system. There are also community-based restoration programs. And going through all of the different options for competency and how those systems work would probably be a series of discussions later. But I just want to flag that it's out there. And again, it's one that if you see someone who doesn't seem to be understanding, be sure you make the judge hearing the case aware of it. And again, as an indication of a need to appoint counsel in the interests of justice. And then one of the other things which really leads us into reentry is what are available for people in the community. So how do we take someone who's been in the jail, whether they were there for a day, a week, a month, or an extended period, and help them to get back to their services in the community? And this really goes back to our initial quarterly meetings, working with your local mental health authority, your intellectual developmental disability authority, your behavioral health authority, to set up procedures with the jail so that when someone posts bond, if they get released on probation, if they plead to time served, whatever it may be, that there is a warm handoff to get that person and their information back in touch with whichever is the most appropriate of the local providers, to get them in touch with a doctor for an assessment. Typically, they'll need a new assessment, new prescriptions for medications, get them connected with their payer, which frequently could be Medicaid for their mental health medications, and then facilitate support services to help them. And that gets back to those service packs we were talking about, with what do they need when they first get out in the community and what do they need on an ongoing basis. And then at the end of the intercepts, we get to community corrections, where someone who ends up on probation. With this one, we get another part of the alphabet soup, which is TCOME, the Texas Commission on Offenders with Mental Illness, that most of your probation offices will have officers that are funded by state grant funds that are specifically trained to help work with people with mental health issues. Another stakeholder for your meeting to have theirs part of the discussion and to facilitate what needs to happen to help the defendant understand what they need to do with their probation, to continue accessing services, to get reconnected to services. And in a lot of cases, the community corrections is going to be doing reentry as well, because it's someone who is detained from the time of their arrest until they ended up resolving their case, or maybe they got out on bond and then got rearrested for bond violations. And so community corrections needs to facilitate reentry. It may be a need to assist with housing. Again, it's that continuity of care to be sure all the information goes forward. Is there counseling that this person needs to help them work through with both the requirements of their probation and the requirements of dealing with their mental health challenges or intellectual disability challenges? And so that's, as I said, a very quick, very high level run through on the checklist. You've got the entire checklist at the end of the PowerPoint, but we also wanted to save a little bit of time at the end because of the number of things going on with the mental health context, with intellectual disability, with substance abuse, to give you the chance to ask some questions, to brainstorm challenges that you've run into working with people in the criminal justice system, and so that we can provide you as much assistance as we can. With that, please either put any questions in the chat or raise your hand, and we'll be happy to answer any questions you've got.
Well, I don't see any questions, Bill, but could I flag one for either you or Jay? So when you talk about these emergency detention cases, can you give an example of how that would work?
Absolutely. Jay, you want to take this one or you want me to?
We don't, okay.
You're good.
We don't do a lot of that. So I haven't done that in a long time since I did those dockets on a rotating basis. So I'm a little afraid I might say something that has been changed.
So with an example of an EDO, in fact, one I used to see at my former office, we might have a client that was out on bond on a family violence and might be having a mental health crisis. We attempt to work with the client, attempt to work through it, and the client is not calming down. The client is making threats against a family member. They are off of their medications. And at that point, either, again, it doesn't have to be a family member, but someone other than the individual themselves, because the idea is the individual could check themselves in to the mental health authority if they were agreeing they needed the emergency help, can fill out an affidavit describing the symptoms they're seeing with the person, the specific reasons they feel the person is an immediate threat and that needs to have inpatient treatment. And then they can work with, typically it would be the county attorney's office in a lot of jurisdictions. It may also be the criminal district attorney's office and jurisdictions if you only have a criminal DA rather than a DA and a CA, to go before either a magistrate or the probate court judge to get a warrant for that person to be taken into custody and then transported to your local mental health facility for assessment and treatment. And typically, that's a very short period of time. It's going to be 24 to probably no more than 48 hours, and then there'll have to be another hearing in front of the probate court to move forward with it.
Yeah, in Galveston, the DA's office has contracted with an excellent lawyer named Chris Johnson, who does all that for us. I know that I'm very interested to hear, because once they go away, we don't really see what happens at the probate court. But I know I've been told that our new wellness center that they're building in Galveston, if the people don't want to stay and they've been referred there and they meet the criteria, that they're going to write EDOs for them. And then they're going to then, I guess, end up in front of a probate judge. So I'll be anxious to see how that works.
Jay, you brought up a great item I should have pointed out as well. One of the biggest challenges for defense attorneys with emergency detention orders is that frequently the information from the probate court does not get back to the criminal court. And this is also where the continuity of care with HIPAA comes into play and is incredibly important, because, of course, that is just as important for their treatment on the civil side with the probate court as it is for their treatment in the criminal court with their criminal case, dealing with what may need to happen at the jail or in the community from that side.
Yeah, when you're dealing with the DA's office and you're trying to get them, the DA's office we find is very receptive. And I mean, I've done this in other counties back when I was with the RPDO, very receptive to looking at defendants with mental illness differently than they look at other defendants. And so whenever you're trying to go down that path and say, look, we need to help this person. They didn't, they weren't on drugs. They didn't ask to do this. This happened to them. Then that CCQ, that information, you need to get that. That's like bringing them a blank criminal history when you're advocating for your client in a regular situation, or them showing you that they've have a prior murder. I mean, it really means everything. So you have to try to get a hold of that and that's where you have to figure it out in your own county. We're lucky we have access to that, but that's it's super important.
So Bill, this is Judge Phillips. I just wanted to follow up, tag on to one thing. As you went through the sequential intercept model, and you may have covered this, but I would highly recommend any of you that are in a county that has not done what we call a SIM mapping meeting, that you do that. You can reach out to the Judicial Commission on Mental Health, which and they can either provide potentially free. They've done 2 in my county, and we did one for juvenile and for the adult system. And it helps you really identify and talk about these issues and to make sure everybody's not in their silos, that we're all working together. And if you've not done that exercise, it's very helpful. And so I would certainly want to give that a shout out. The other aspect is when we talk about competency restoration and the jail-based competency restoration, it's amazing that works instead of someone having to sit in jail for 2 years. You don't have to be a big county to set that up. I mean, Grayson County, where I am, we got about 130, 140,000, maybe 150. We keep growing so fast. And so we have implemented one and we're still working on it. But the key to that is you have to have the county and the sheriff's department willing to consider making the defendant take medication, because that's ultimately what's going to happen in the state hospital. And they don't want to take that medication. So as defense attorneys, as defense coordinator, you have to make sure you're protecting their constitutional rights through all of that, but also understanding that when this person screams and yells at you, wanting that we all know that him or whoever it is sitting in jail for 2 years, not medicated, harming potentially staff or themselves or whatever, is not a good outcome. And so that's why the jail-based competency restoration is being really pushed now, and it's exciting. So just wanted to say those comments, but y'all covered it greatly. Thank you.
And Judge, thank you so much for bringing up the sequential intercept mappings, because it is absolutely vital. And you will discover, as the judge said, people in their silos you did not even realize were out in your community. That when everybody comes together and identifying what services are available and how you can really leverage your resources. One of the other great advantages of the jail competency-based restoration is because it's in your county, there typically is not a long wait to get in. And so someone may have completed their restoration and be restored, if they're going to be restored, during the time they might be waiting for a bed going to the state hospital.
And they don't lose their place. That's something I want to mention. They don't lose their place if they go through that. That's some people are not sure about that. So I think that's important.
Any other comments, questions? Anything you want to brainstorm?
I could have a second question here.
Go for it, Joel.
As far as these quarterly meetings, do most counties have them? How do you start them? How does that work?
All that really is somebody has to start them. It can be, I've seen it done by the public defenders. I've seen it done by the prosecutors. I've seen it done by the judiciary. It's just, in fact, it could even be the sheriff or the one of the local authorities, whether it's mental health, behavioral health, or IDD. But it's just a matter of whoever can get everybody coming together into the room to start having those conversations. And again, part of that is you need everybody together, but you don't have to have everybody to start having them. The more people you can get, it will snowball and start growing. I've seen them start from just having law enforcement meeting with the local mental health authority because they got frustrated over the time they were spending in the local hospitals waiting on somebody to get stabilized. But it just takes a group that wants to get it moving forward and make strides for your community.
In my community, we started a nonprofit, and we have all kinds of people involved in that board, and we put on an annual conference. But getting back to kind of the people, and most of the sheriff's been on it, the district attorney's on it, the LMHA's on it. Everybody's kind of at a seat at that table. Our mental health hospital, so it's even broader than just in the criminal justice. But under that, we have a criminal justice, I guess, subcommittee that discusses all, focuses on what you're talking about. And we've done that for several years, and sometimes it really works great, sometimes it doesn't. But out of that process, we now have our local LMHA as a crisis intervention person embedded in our local police department. And they're there from 10 to 10, and they go out on calls if there's an issue related to mental health, so that they're there with the police officer. So that would never have happened had we not started that leadership team and had everybody kind of on the same page. And so just like, if you try to get a SIM mapping in your community, that could be a good jumping or springboard to establishing a more of a county-wide mental health, not authority. It's not a governmental agency. It's just everybody coming together.
And Judge, with your intervention teams, does your mental health authority do training for your police department as well for those teams?
Yes, but they are LMHA employees that are with them. But we do the mental health training and of course the law was changed to require law enforcement to have certain mental health training. We've done that. We've applied for grants to try to train all of ours. And so, yes, it's really that continual training for them. Once they know how to handle a situation and they realize, okay, I need to step back. How do you de-escalate this situation? Who do I need to talk to really understand, is this a regular occurrence? Is this just a unique deal? Can we elevate, because what we don't want is everybody just taken to jail, and because that's not where they all belong. They either maybe in the hospital, or maybe there are things you can do, get them set up for counseling, all kinds of stuff. Yes, sir. Training is key for the law enforcement.
Thanks, sir. Okay, Wesley, let me pass it back over to you.
All right, well, I think that wraps it up for this month. We're going to try and pick these back up on a quarterly basis, and I want to thank our speakers. Jay,
excuse me.
Yes.
I have a question.
Okay.
So our county is a lot small. It's a smaller county, and if, let's say, a magistrate judge has yet to magistrate a defendant on a criminal charge, and what is the process? Do they have to immediately file a 1622 or have an attorney already appointed prior to filing the 1622? I've had an issue where I've had judges contact me for me to appoint a mental health attorney, an attorney that handles defendants with MI. But that's not what I do. as a indigent defense coordinator, I only appoint for felonies, misdemeanors, juveniles, and CPS. What is the process for what is it that they need to do? Do they need to have an attorney appointed prior to magistration, or do they have to file a 1622 if they know and they're aware that the defendant has MI?
Well, the 1622 is really a little different from your appointment process. Your appointment process is if someone requests an attorney and they qualify, or again, you may determine to appoint in the interest of justice, like for someone with mental illness. Whether they have mental illness or not is a little bit different from whether or not the magistrate finds that a 1622 assessment isn't necessary. And they don't have to have an attorney appointed to have a 1622. In fact, I would say in most counties across the state, an attorney won't be appointed yet. That may be happening almost in parallel with the magistration at 1517. Remember, under the Code of Criminal Procedure, magistration has to happen as soon as practicable, but it shouldn't be over 48 hours at the outside. But when you're saying they're asking you to appoint for something you don't normally do, is it something other than for the criminal case? Or is it to appoint a mental health attorney to deal with whatever their criminal charges were?
To deal with the mental health process, like we do have our county court coordinator. She normally appoints for mental health defendants once the 1622 is filed. But it goes through that process. But I solely appoint for the criminal procedure.
Well, and
process of it.
I think this is where we may be going a little bit at cross paths. You still have a requirement to appoint for the pending criminal case under the timelines. If you're a really small county, then you're going to be in the under 250,000 timeline. So by
Yes.
the third day, you've got to have reviewed their application. If you determine they're appropriate either for income or because of mental health, go ahead and appoint. Now, if you're talking about appointing for the guardianship process, that would be very different.
Okay, that's what I wanted to clarify, because if, for instance, that judge reaches out, but I don't have an affidavit, there's no magistration yet, and that magistrating judge wants an appointment, without me receiving anything, what is it that I should do in that circumstance?
If the magistrating judge is telling you you've got somebody with mental health issues and they need an appointment in connection with that case, then you need to appoint within the time periods for your county. Again, I think we maybe go a little bit cross purposes. The 1622 has nothing to do with a guardianship appointment.
Okay, I just wanted to clarify that information. So even if I do not receive any documentation from the defendant regarding not appointing on the criminal, but appointing in the guardianship matter that I do not handle.
I understand. I'm just concerned when you're saying it's the magistrating judge that's telling you there's a mental health issue and that an appointment is needed. If that's in connection with a misdemeanor or a felony case, and the judge is saying this person's mentally ill, then it sounds like the judge, and you may want to reach out to the judge and ask them to confirm or send you an email so you have documentation that the judge is asking you to appoint in the interest of justice.
Great. Okay, I just wanted to confirm that information. So I can appoint on the interest of justice, and I just appoint on the regular felony wheel because I do not have a mental health wheel.
If you don't have a mental health wheel, then you'd appoint on the applicable wheel.
Okay, great. Thank you so much. I really appreciate the feedback on that.
Judge Phillips, I see you.
Yeah, I was just going to follow up on that because we've had this come up where you have an individual, because of mental illness, they won't talk to you. They're not going to provide any information. You will never get possibly any of that information from them. But clearly that's an example of you're not going to get that, but you still have to follow that timeline and appoint somebody. And generally, like, you're going to have, our coordinator, indigent defense coordinator, is the one that goes down and interfaces. And we had a judge question that. We said, no, we researched it. In fact, it's wrong not to. So that's all we suggest that. The other thing, just so the 1622, again, that's involving criminal things. And the 1622, not all magistrates in the state are following the law and considering that, unfortunately, across the state. So it's really important that, especially if the case has been filed, that you come back and if you got not the magistrate, but the trial court it's before pending and something comes up, there hasn't been a 1622, person identifies. Sometimes it takes a while for them to be in jail for some of the it's all of our responsibility. Whoever knows about it, whether it's jail, the defense attorney, hopefully not the prosecutor's been talking to them, so hopefully it's not them, but whoever has that knowledge, including us, has to consider the 1622 statute.
We've run a little bit over the hour, so I think we have to close this out, but we're going to put this on YouTube. And if you need CLE or coordinator credit, that you can do that. You can either look through the PowerPoint slides or rewatch this on YouTube if you're unsure how to do that.
That sounds
Thank
good.
you, everyone.
Thank you.
Take care, everyone.